Assalamualaikum and a very good day to our lecturer, Dr. Yohanif. Our group will present on the topic of nervous shock. Our group consists of Aini, Afifah, myself Nilam, Anis, and also Nur Amirah. Introduction. Nervous shock, or the preferred expression nowadays, is a psychiatric injury or illness is a type of damage that has been continuously argued in the judicial system. Harvard 1956 described nervous shock as damage from emotional shock, or in medical language, it is also known as somatic or psychic, or rather often it is a combination of both. According to Law of Tort II in the case of McMullen against OBrien, it must be differentiated from severe fear or emotional distress, grief or sorrow, except it lead to either physical illness or positive psychiatric illness. In an article published in 1905, Mr. Hugh wrote that a man's nerves is also a part of a person's personality, which is as part of his limbs. Thus, it is also appropriate subject for legal protection. And therefore, this report writing will include an in-depth view on the law of nervous shock, as well as the case decided in its state of development. The earlier cases. The development in the law of nervous shock gradually expanded through decades, where originally the court would not allow any claim on psychiatric illness, except only with actual physical damage. But it changes in the case of Dulu and White and Sons. The defendant was held liable for causing the plaintiff to suffer shock when her workplace was crashed due to the defendant's reckless driving, which subsequently caused her miscarriage. In another case, which is Hamburg and Stokes' brother, in this case, Banks Lord Justice described the case by giving a situation of two mothers. One mother is courageous and devoted to her child, and another woman is timid and lacking in a motherly instinct. In the Malaysian case, which is Zainab Ismail against Marimutu and Anwar, the plaintiff's claim on nervous shock was successful, as it was argued by the plaintiff that she saw her daughter being knocked down by a lorry drove by the defendant. Thus, it can be seen that law on nervous shock was already established in Malaysia in mid-20th century. In the last case, which is Dooley and Camel Laird and Co. Ltd., it was held that plaintiff could claim for nervous shock that he suffered when he saw the load on the crane fell onto his workmates on the ship as a result of the cable of the crane snapped.
Next is the emergence of current law. In the case of McMullen against OBrien, this is a landmark case where the requirement that the secondary victim be close to the scene of the accident. The plaintiff's husband and 3 of her children involved in a serious road accident caused by the defendant's negligence. However, the plaintiff did not witness the accident by herself. Plaintiff then was informed by her friend that her son was dying and rushed to the hospital. Upon arriving, she was told that her 3-year-old daughter had died. She also saw her husband and 7-year-old daughter covered by oil and mud. This event caused her to suffer nervous shock. The issue in this case is whether the plaintiff could recover, as she was not at the scene when the accident occurs. The court decided that nervous shock was reasonably foreseeable, and there are 4 factors that need to be considered. First, the class of person that can claim is the closest in the family ties. For example, parents and children, husband and wife. In this case, the plaintiff is the wife, so she is considered to be the closest in the family ties. Second, there must be a physical proximity to the accident, which include the plaintiff who does not see the accident but sees the immediate aftermath of it. The plaintiff had not seen or heard the accident itself, but had come upon its immediate aftermath. The plaintiff had seen her family within a short time of the accident, and they had not been cleaned up and remained in the same condition as they had been immediately after the accident. Third, the means by which the psychiatric illness was caused either be as a result of what plaintiff sees, hears, or if the plaintiff comes upon the immediate aftermath of the damage. The fourth factor is the defendant negligence is one of the psychiatric condition that is medically recognized. If all of these factors had been fulfilled, then the plaintiff can recover the damages.
Okay, Assalamualaikum warahmatullahi wabarakatuh. Next, I will be explaining the current law in Malaysia. So, we will refer the case of alcohol against Chief Constable of South Yorkshire Police. In this case, the defendant was sued because of negligently allowing too many spectators entering the confined area of the stadium, causing part of the stadium to collapse. So, this caused 95 of the people died and more than 400 suffered injuries. The incident was televised live and reported in new broadcasts. The claim of nervous shock was made by 16 people. Four of them were at the stadium where the incident occurred, and the rest saw their relative body at the morning. One of the plaintiffs was the fiancé of one of the victims. There is no claim made by the parents or spouses. The defendant admitted there is negligence on the part of them, causing death of the victim and injuries to the victim, but denied the duty of care to the plaintiff. So the plaintiff argued that there is a duty owed by the defendant to them if the damage of psychiatric illness was reasonably foreseeable. So, the court held that a claim of nervous shock may succeed under some circumstances. First, it is foreseeable that the plaintiff will sustain psychiatric illness due to the close relationship and affection with the primary victim. Second, there must be a physical proximity, time and space. And third, the nature of relationship between the plaintiff and the victim is an important. So, the court held that one of the plaintiffs failed to prove that he had a close emotional tie with his two deceased brother. Thus, his claim was denied. The shock must be caused by the actual sight or sound of the accident or immediately aftermath. The plaintiff, in this case, failed the immediate aftermath test as they only saw the bodies some 9 hours after the tragedy.
Assalamualaikum warahmatullahi wabarakatuh. Now let's proceed to classification of victims. Victims can be classified into primary and secondary victims. In Dulio and White, the court stated that the plaintiff is a primary victim when he himself suffers physical injury which subsequently results in nervous shock. However, the courts have allowed recovery for nervous shock to plaintiffs such as rescuers and or participants even though they did not have requisite relationship of love and intimacy with the primary victim. The first one is rescuer. The justification for allowing rescuer to claim for nervous shock is because it is the defendant's fault for creating a situation which calls for rescue. In Chadwick and British Railways Board, 90 people were killed and many more were seriously injured in a railway accident. The plaintiff who witnessed the accident went to the scene to assist in rescuing the victims. He worked many hours through the night crawling beneath the wreckage to bring aid and comfort to the trapped victims. As a result of what he had witnessed, he suffered nervous shock. His claim was allowed by the court. The plaintiff is deemed to be within reasonable contemplation as persons who might suffer nervous shock as a result of aiding the victims. In Hill and London Underground Limited, there was a fire at the London Underground train station. The plaintiff, who was a fireman, assisted in the rescue operation and subsequently suffered nervous shock due to it. The defendants were held liable. Presently, if the rescuer is a member of the public, Chadwick case will be applicable. However, if the rescuer is a member of the emergency services, the court will not automatically allow for a recovery. This is evident in White and Chief Constable of South Yorkshire Police, in which police officers had been negligent in directing an excessively large number of spectators to one end of the stadium, which resulted in the fatal crash in which 95 people were killed and over 400 were physically injured. The police officers who were on duty that day claimed against their employer for nervous shock sustained by them due to the rescue operations during the incident. The court dismissed the claims by the plaintiffs on the ground of policy, as it is their duty as members of emergency services. The second one is mere bystander. Nervous shock to a mere bystander who is not related to the primary victim is generally unforeseeable. In Borhill and Young, a pregnant woman suffered a miscarriage through the shock of hearing and witnessing the aftermath of a road accident caused by the defendant's negligence. The court held the defendant did not owe the plaintiff duty of care as she was not within the area of foreseeable impact. The third one is a bystander who is a participant. In McMullen and EE Caledonia Limited, a series of massive explosions occurred on the oil rig while the plaintiff was on a support vessel 550 meters away from the rig. He witnessed the incident and the subsequent destruction of the rig before he was evacuated by helicopter. The closest the plaintiff came to the rig was 100 meters when the support vessel moved toward the rig in order to assist. The plaintiff claimed damages from the defendants on the ground that he suffered nervous shock due to the incident he had witnessed. The court held the defendants as not liable because they did not owe the plaintiff duty of care. In deciding this, the court laid down several principles. Firstly, to recover damages for nervous shock caused by fear of physical injury to himself in horrific incident, a person will be considered a participant and may recover damages if he was present in the actual area of danger created by the incident, or he reasonably thinks he is in danger due to the suddenness and unexpectedness of that incident, or although originally he was not within the area of danger, but later on he comes into the area as a rescuer. It is important to note that the class of persons to which duty of care is owed must be within the defendant's reasonable contemplation. If a primary victim, such as a driver, suffers from self-inflicted injuries due to his own carelessness, such as reckless driving, he owes no duty of care to a third-party rescuer not to cause nervous shock to the rescuer. This is shown in Greatorex and Greatorex. In this case, the defendant drove a car recklessly and was involved in a head-on collision with another vehicle. Consequently, he was trapped in the car and was unconscious due to a serious head injury. The plaintiff, who was a rescuer fire officer, sustained nervous shock as a result of rescuing his son, the defendant. The court held the claim failed because a primary victim does not owe a duty of care to a third party in circumstances where his self-inflicted injuries caused that third party nervous shock. Furthermore, the claim also failed due to policy grounds. If the plaintiff himself is involved in an accident and suffered only nervous shock with no physical injury, he is a primary victim and can recover damages. This is illustrated in Page and Smith. In this case, the plaintiff was involved in a car accident. There was no physical injury, but the plaintiff suffered an acute form of chronic fatigue syndrome and he could not work. The House of Lords allowed the claim as the plaintiff is a primary victim because it was foreseeable that he would be exposed to physical injury in consequence of the accident. Once injury to a primary victim is foreseeable, he can claim for any physical injury or nervous shock arising from the accident. On the other hand, if the plaintiff is a secondary victim, he must satisfy the test in Alcock case.
Assalamualaikum, my name is Anis Kemilia binti Husaini and my matric number is 265137. Moving on to the next part, which is the flexibility in the meaning of secondary victim. So a secondary victim is the one who suffers nervous shock without being directly exposed to any physical danger in the accident to the primary victim. There are some qualifications as a secondary victim. The first one is having a relationship of love and affection with the primary victim. Second, there must be an immediate aftermath of the event. Third, have a direct perception of the harm to the primary victim. Last but not least, must be of reasonable fortitude. The distinguishing between primary and secondary victim was challenged in the case of W against Essex County Council, where the fact is the foster parents wished to foster another child and explicitly told the council that they did not want a child who had been or was suspected of being a child abuser. The child who they subsequently fostered sexually abused the existing foster children. Therefore, plaintiffs sued defendant in negligence and claimed that they had suffered psychiatric illness, including severe depression and post-traumatic stress disorder after learning of the abuse. So the court allowed the recovery as the categories of primary and secondary victims are not fixed. It is arguable whether the foster parents could be classed as primary victim. So this case clearly shows that the boundaries of liability for psychiatric illness are not explicit and are fraught with policy consideration. Moving on to the next part, which is recoverability limited to physical injury. So, recoverability for nervous shock is not only limited to physical injury. In fact, it is broader and extends to psychiatric injury sustained due to damage to things or property. But unfortunately, the necessary criteria for recovery today are still unclear. So this can be seen in these two cases, which the first one Owens against Liverpool Corporation, where the fact is the plaintiff claimed damages for nervous shock from the defendant when the latter negligently collided with a hearse, causing the plaintiff to fear for the state of the corpse. The held is the plaintiff successfully recovered the damages for psychiatric illness caused by negligence of defendant, which concern as to human safety was involved. In other case, which is the Atia against British Gas, where the fact is the plaintiff had witnessed the destruction of her house and its contained by fire due to the defendant employee negligence. So the court allowed the plaintiff to recover damages for nervous shock. It is also significant to be noted that the plaintiff is a primary and not a secondary victim. Therefore, there is no special restriction applied in that situation.
Conclusion. In conclusion, the law on nervous shock has been long established and there has been an array of judicial review all around the world. Over the last century, it has massively expanded until today it has been recognized on its own category under the law of every jurisdiction. The sequel of this category of law has certainly caused burden to the defendants and the court. Last but not least, there are continuous development on this area of the law and there will be changes from time to time. Thus, the application of the principle discussed might be useful for today. However, it is not definite for the future references. That's all from us. Thank you.